Welcome to another edition of Shaftesbury Society, coming to you live from Midtown Raleigh at the headquarters of the John Locke Foundation. I am so glad you are with us today because we have a hot issue to discuss with you today, a critical issue to the future of North Carolina. In fact, an issue that is already making national news. How do we know? The Wall Street Journal on Sunday running this editorial about North Carolina, about the issue we're talking about today, scorched earth judging in North Carolina. A liberal state Supreme Court gambit threatens political legitimacy. This is something that you need to know about and share with your friends, and that's why we're here today. A key legal case is going to determine the fate of voter ID in North Carolina now sits with the North Carolina Supreme Court. Now, opponents, as you probably already know, have succeeded in preventing the implementation of ID in our state for several election cycles. But a new scheme, the scheme written about in this editorial by the Wall Street Journal on Sunday, and also by Carolina Journal's Dallas Woodhouse. This scheme to boot two Republican justices from the state's highest court, preventing them from ruling on the voter ID case. It would hand the Democrats a 4-to-1 majority from which they would decide the fate of voter ID. And of course, you know, voter ID was passed overwhelmingly by North Carolinians in 2018. So what about this? What do we know and where is this going? That's what we're here to talk about today. Joining me, first of all, is Jeanette Doran. She is the President and General Counsel of the North Carolina Institute for Constitutional Law. Also on our panel, my colleague Mitch Kokai, who is Senior Political Analyst with the John Locke Foundation, and my colleague as well, Dallas Woodhouse. Dallas is the Investigative Political Analyst for Carolina Journal. He's been writing about this story, the first to know about this, the first to report on it at carolinajournal.com. Folks, thanks very much for joining me today. Mitch, first of all, let's start with you. Bring us up to date. Tell us exactly how we got to today.
Folks in North Carolina might remember, Donna, that back in 2013, the General Assembly passed voter ID as part of a series of election reforms, and that whole package of reforms ended up getting thrown out by the courts. So voter ID supporters went back to the drawing board and decided, it would be good to put voter ID within the state constitution. This is something people want. Let's go ahead and make sure it's something that's going to be part of our constitution. And then whatever legal issues come out, we'll know that we still have voter ID there. So voter ID was put as an amendment on the ballot for voters in 2018 as part of a package of 6 amendments. Voters ended up approving voter ID and 3 other amendments. They also rejected 2 amendments, but that voter ID amendment got passed with about 55% of the vote. Voters also approved an amendment that would lower the state's existing constitutional cap on income tax rates. There had been a 10% cap. The amendment lowered that cap from 10% to 7%. That also got an overwhelming vote. But despite that fact, the NAACP didn't like the fact that those 2 particular amendments were approved by voters. They didn't seem to have any problem with amendments that would add more victims' rights to the Constitution or to deal with hunting and fishing rights, but they didn't like the tax cap or voter ID, and so they filed suit. And the interesting part of the suit was that it basically said the General Assembly did not have the right to put these amendments on the ballot because they had been gerrymandered into their position. Once this went to a trial court, a Wake County trial court judge bought their argument and said, okay, that makes sense to me that a gerrymandered legislature shouldn't be able to do this. Got through the trial court, went to the State Court of Appeals, which in a 2-1 ruling reversed that and said, no, wait a minute, this doesn't make any sense. There's no legal precedent to be able to throw out the things that a duly elected General Assembly, even one that has had the influence of gerrymandering, can say. And by the way, the ultimate decision on these amendments was from the people, the voters who voted to favor voter ID and the tax cap. So the Court of Appeals, by a 2-1 ruling, reversed the trial court, but then the NAACP decided to appeal. So now the case has moved to the state Supreme Court, and that's where the action stands right now.
And in fact, Dallas Woodhouse, reporting for CarolinaJournal.com, analyzing what is happening behind the scenes. Dallas, you were first on this story. We're now at the North Carolina Supreme Court, and there is an incredible, some say an unprecedented challenge by the NAACP on the voter ID case, trying to essentially boot off of the judging panel two Republican justices of the North Carolina Supreme Court. Tell us what's happening.
So a couple of things that I think we ought to start out with, and thank you for joining me today. And I want to just say how pleased I am that the John Locke Foundation has let us pursue this story, because it has taken a lot of twists and turns. Number one, remember that there are separate voter ID issues. One is the statute that enables voter ID. That has been blocked. That is not an issue of what we are talking about here today. The issue is the amendment that requires voter ID, which of course North Carolina can have voter ID with or without the amendment. As Mitch explained very succinctly, those two amendments were passed overwhelmingly by 11 and 15 points respectively in 2018. So the Democrats control the state Supreme Court 4-3. To throw out the amendments, they would have to rule that the amendments should have never been placed on the ballot to begin with, because they can't rule the amendments themselves unconstitutional. A part of the Constitution cannot be unconstitutional to itself. And you use the word unprecedented, but all of this is unprecedented. We have the unprecedented nature of a court declaring an entire legislative body unconstitutional. While North Carolina's had a lot of redistricting issues come up over the years, we are certainly not the first and will not be the last legislature where the districts have to be altered. The idea that an entire body of work of a legislature is invalid has been rejected by numerous courts throughout the years. North Carolina has never had a situation where a court has rejected amendments that have already passed votes of the people. Now, we have had parts of the Constitution ruled unconstitutional federally. They were federally unconstitutional, but we've never had a situation where amendments, state constitutional amendments, have passed and then been thrown out. And now we've never had a situation. Normally, justices are asked to make their own judgments about recusals. And so the NAACP has made a move, which I quite frankly thought was laughable at the time, to forcibly move Justice Tamara Berenger and Justice Phil Berger Jr. Off the court. Their reasoning being that Justice Berenger was in the legislature when those amendments were passed, and that Phil Berger Jr. his father is quote unquote a named defendant, and I'll get back to that in one quick second. There is multiple case law in North Carolina. Many times this has been decided with respect to Judge Berenger that it is not a conflict to have been in the legislature and then later rule on the constitutionality of laws that when you were in the body. We have had numerous Supreme Court justices that have gone from the legislature into the courts. So this would be overturning 200 years of precedent. The situation with Justice Berger, as most people know, his father is the Senate President pro tem. He is technically the named defendant in the lawsuit, which is NAACP versus Tim Moore and Phil Berger. That is a technical designation. The defendants in this case are actually you, Donna, and Jeanette, and Mitch, and me. It is the state of North Carolina, not Mr. Berger personally. The law actually requires that Mr. Berger, the senator, be named in the lawsuit. But if he would have quit the legislature tomorrow, they would replace his name.
And despite that, Dallas, so the NAACP in its challenge is saying that this is a conflict of interest for both of these two new justices, newly elected justices to the Supreme Court.
That's correct, Donna. And here's what it boils down to, that we believe it is very simple. The Democrats, obviously, with a 4-3 vote, as constitutionally and legally dubious as it would be, could right now hold a hearing and decide to invalidate the amendments. I think that would be misguided and not based in the law, but they could do that. But the Democrats have a tenuous 4-3 to majority. 2 seats are up for election in 2022. One of those is held by Senior Justice Robin Hudson. Justice Hudson is expected not to run again, very unlikely to run because she is facing the mandatory retirement age. But Justice Jimmy Ervin will be up in 2022, and we believe this is an effort to try to protect him politically. So if you throw the 2 Republican justices off, you then have a 5-member court and 3 Democrats, Anita Earls, Mike Morgan, and Robin Hudson, could vote to get rid of the amendments while letting Mr. Ervin vote on the other side. There is another possibility that they need to remove the 2 Republican justices because they don't have all 4 Democrat votes. Either one is dubious, it is constitutionally suspect, and it could have severe and long-lasting ramifications for our judicial system in North Carolina.
In fact, Jeanette, I just want to read a line from this Wall Street Journal editorial. Again, this is from the October 3rd Wall Street Journal, the editorial board. Here's one thing they have to say about what could be transpiring here in North Carolina. They write, "It's worth reviewing the radicalism of what may be transpiring." Jeanette, the Wall Street Journal uses the word radicalism. Is this unprecedented? And what are you hearing in the legal community about what we now know based on a briefing order seems to be a real consideration of the North Carolina Supreme Court to move forward on the potential of removing 2 justices from this case?
Well, it's certainly a first of its kind situation. I think it would be fair to describe it as unprecedented, seeking to disqualify 2 very recently elected justices. And as we talk about it, both here and as I talk with my fellow attorneys in the broader legal community, it's really alarming to think what the parties have at stake here. What they're suggesting is that the court should basically ignore last year's election of Justice Berger and Justice Beringer. Let's keep in mind, this case had been going on for years. Voters were aware that this case was out there when they elected Berger and Beringer just last fall. Also, voters were aware that Justice Beringer had served in the legislature. That was something that was very well documented. It was part of her campaign strategy. And voters were well aware that Justice Phil Berger, now Justice Phil Berger, is the pro tem's son. So what this is really just a slap in the face of voters. It's activists with the NAACP and others saying not only that the voters were wrong in having ratified the amendments at the core of the case, but they're really saying the voters were wrong to have elected 2 of these justices.
And Jeanette, that's such a key point, because what we're talking about here, folks, is not only if this were to go forward and actually happen to have these 2 justices deemed essentially unfit to rule on this case, then you're talking about overruling, usurping the will of the North Carolina voter, not only on the voter ID amendment that passed overwhelmingly in 2018, but remember that here in North Carolina, we elect our justices. And so, Jeanette, to your point, those folks were on the ballot. They each received several million votes in order to take the seat on the North Carolina Supreme Court. I mean, there was a contest and voters made a choice. So it's almost as, I don't know, a twofer or a threefer, if that's a word. If this happened to usurp and overturn the will of North Carolina voters, it just seems incredible.
Hey, and potentially destabilizing for the court at large. I mean, think about it. If this motion is successful and these justices are disqualified by their fellow justices, think about how many times this will come up in future litigation. Basically, anytime there's any sort of a challenge to legislation, you're going to have a party that says Beringer needs to be out, Berger needs to be out. This is not just this case. And the court let's keep in mind, the Supreme Court is well aware that the decisions they make are not made in isolation and they are not just for that one case. They're creating the jurisprudence of the state of North Carolina, the 9th largest state in the union. They're going to be aware, or should be aware, of what this means, not just for this case, but in cases to come.
And Dallas,
Donna, if you add up what the NAACP, the liberal left, and the Democrats on the Supreme Court, if you add up the positive votes for the 2 amendments and the combined vote totals of Barringer and Berger, you are talking about nullifying over 9 million votes. There was only 10. I mean, if you want to look at it in the scale, there are about 10 million people in North Carolina. You'd be nullifying 9 million separate votes. And we already have seen where this is going. There is another case involving the rights of felons to vote. The state constitution says felons cannot vote unless there is a statute put in place by the legislature. The current statute requires that you finish your sentence, that you pay your fines and finish probation. And that law is now under challenge. And the NAACP has used the same logic to again file a motion to remove Phil Berger Jr. because his dad's a named defendant. Here's the interesting part of that case. The law in question was passed in 1971. Phil Berger Jr. was still in diapers. Phil Berger Sr. Worked at a press mill in Virginia. He had to pull out metal shards out of his hands, and his hands were all cut up every night. It's what caused him to further his education and go to community college. He eventually became a produce manager at Kroger, painted houses, worked his way through college, and eventually graduated Wake Forest Law School. But by the time when that law was passed, it would be another 33 years before Senator Berger would become Senator Berger, before he would enter the legislature, and another 4 decades before he became the leader. So, this is the ridiculousness this gets into.
what I'd like to do is to talk about the actual precedent, so to speak, when it comes to the claim by, or the challenge by the NAACP of conflict of interest. Let's talk, if we could, about Justice Tamara Barringer. Okay, she was a state legislator. Is there any precedent? Has any justice been removed from a case or voluntarily recused simply because he or she had been in the legislature and then they somehow determined that this was a conflict once they were on the court?
It's really interesting. And I blogged about this maybe a month or so ago. I think one of the best examples is Justice Wichard. Willis Wichard served in the House and the Senate, on the Court of Appeals and the Supreme Court. And he very frequently considered the constitutionality or the statutory construction of statutes that were before him when he was in the legislature. And nobody seemed to have a problem with Justice Wichard sort of taking off the legislative cap and putting on the judicial cap and robe. That was never a problem. And it isn't a problem now. Justice Barringer was one member of a very large body, and that body put forth these referenda to the voters, and it was really up to the voters. So there's really not a conflict there. It's a seductive argument on their part because people have this, if you don't stop and think about it, you go, oh, well, she shouldn't be able to do that, shouldn't be able to review this. But when you think about the history in North Carolina of people like Justice Wichard having served in the legislature and then the judiciary, this has not historically been a problem.
And in fact,
there are no, I want to stay on the precedent because you asked about voluntary recusals. There have been some voluntary recusals for various reasons over the years. And of course, we, nobody is saying that if a judge believes they're conflicted, they shouldn't voluntarily recuse. In 200 years of the North Carolina,
not be voluntary.
Yeah, in 200 years of the North Carolina Supreme Court, there has never been a situation where one group of Supreme Court justices forced another off ever. And to our knowledge, it's not been practiced in any other states. And of course, what's amazing about this, the real conflict of interest in this case is with Democrat Anita Earls, who was the attorney for the NAACP and worked on this case in particular. And what I reported over just the last couple of days, which I just found shocking, is that in late February of 2019, Judge Brian Collins issued that ruling in the lower court that Jeanette referred to that threw out the amendments. 5 days later, Anita Earls, then a Supreme Court justice, was the headliner at a fundraiser for the NAACP, the plaintiff in this case. I mean, she was raising money for the plaintiff as a Supreme Court justice, all well knowing this case was headed to the Supreme Court. I mean, once the lower court ruled this, of course it was headed to the Supreme Court. So that is a real conflict of interest. Now, I personally think this ought to be left to the voters. You know, the reason we bring up Anita Earls, Mike Morgan has also raised money for the NAACP, is that it would be egregious to force off the Republicans and the Democrats not go off. And of course, as Jeanette knows and Mitch knows, that recusals are quite different in the lower courts because you can find another judge. The state Supreme Court is a court of last resort. There is nobody to go to. You can't replace them. So it changes the balance, changes the mix, and it changes what the voters have approved.
And to follow up on what Dallas just said, no one is calling for Anita Earls to be forcibly removed, despite the fact that she seems to have much more of a conflict of interest than anyone else in this case. No one is saying, let's force Anita Earls out. Just let all of the justices participate. If they decide that they have a conflict of interest, then they can recuse themselves. And perhaps Justice Earls might think that, oh, having worked for the NAACP, it might make sense for me to recuse myself. But if she doesn't, then allow her to sit on the court and hear the case along with Justices Berenger and Berger and the other four.
And the voters can cast judgment on that at the time.
And interestingly enough, to this point of the Democratic Supreme Court Justice Anita Earls, that also comes up in the Wall Street Journal editorial from Sunday about this. The editorial board there writes, one of the liberal justices, Anita Earls, litigated extensively against North Carolina's 2011 maps before she was elected to the Supreme Court in 2018. Yet, Justice Earls' removal is not sought because a liberal majority to overturn the two constitutional amendments would depend on her vote. That from the Wall Street Journal. You know, it's fascinating. Dallas, you reported on this, and I know, Jeanette, you are following this very closely, as Mitch is. The actual briefing order that came down just days ago. By the way, make sure you're following CarolinaJournal.com and on Twitter and Facebook, Carolina Journal, for the latest analysis from Dallas Woodhouse on all of this as well. This briefing order that comes from the North Carolina Supreme Court. First of all, Jeanette, explain to us just briefly, what is a briefing order? What's the significance of this document that Dallas wrote about just days ago?
Sure. The briefing order comes from the Supreme Court. It appears to be signed by Anita Earls. That sort of stands out as we're talking about her and a potential conflict. But what the briefing order does is it lays out a series of questions and instructs the parties to submit simultaneously briefs addressing the questions of the court. They've got 30 days to do that. And then if the parties want to respond to what the other side wrote, they've got another 20 days to submit that. And the idea is that the court has these questions. We don't know which justices proposed which of the questions. Maybe they all collectively had the exact same questions, but probably there are some questions that certain justices wanted an answer to or information about, and other justices had other questions. So this instructs the parties to brief these very specific questions. There are 8 listed, and each one has a series of subparts to it. So the parties will submit that at the end of this month, and we'll see what they have to say as to each of these points.
You know, the fact that there is a briefing order on this. So, Mitch, what does that tell you as you've been watching the political and judicial landscape here in North Carolina? The fact that there is an order where questions have been written down and posed to the parties in the case, NAACP versus Moore et al. What does that say? It says to me that they're seriously considering this.
Yes, this shows that this wasn't just speculation. I mean, for a while, the story dealt with informed speculation about what was happening. To give people a little bit more background, this case was actually scheduled to go to oral arguments in front of the Supreme Court. So it was on the docket for the lawyers to all show up and give their case, one side and the other, and the justices could throw questions at them to try to get at various legal theories. Up until perhaps as late as the day before, certainly the week before, this case was still on the docket, and then it suddenly disappeared. And the only thing that stood out as a possibility of why it had disappeared was this motion that had been filed back in July by the NAACP to remove the two justices. We should point out Jeanette is the only attorney involved in this conversation right now, and I hope that she'll correct me if I'm wrong on the legal aspects of this. But I think most people who saw that initial motion to try to get Justices Berenger and Berger removed had thought, well, you know, that they're giving this a shot. It's not going to go anywhere. But certainly by the time that this case was delayed and taken off of oral arguments, the informed speculation was, well, maybe they are seriously considering this. And then once the order came out, it was clear that this was actually a point of discussion. The justices were seriously thinking about the prospect of forcibly removing two of their colleagues from this case for the first time in the state's history.
And there are a couple of fascinating questions in that order that I want to bring up. One, and this is what I've referred to as legal bootstrapping, and that is the question of, I don't think Jeanette likes that term, but it's that's what I get from Law and Order. But here's what they're saying. If you're going to have a motion to recuse Berger and Berenger and the other justices are going to vote on it, do they themselves get to vote on it? Or in essence, are they recused from the beginning because they can't ever weigh in? You know, and you can see how the
case, wouldn't that be prejudging the outcome then?
Well, that's what I think.
Automatically recused.
So there's obviously been, and my political sense is, well, that's all about Jimmy Irvin again. In other words, if you sit there and go, they have to recuse themselves from the vote to recuse, then you never have to have Jimmy Irvin on the wrong side. They have the same 3-2 vote to keep them from arguing about against their own recusal, then for the recusal, and then the case.
And in fact, for our viewers, you're talking about a Democratic member of the Supreme Court, Justice Jimmy Irvin.
Right, who is the one that's up in 2022 and politically that they certainly want to protect. But the other question is, how does the court enforce this? You know, I mean, the court has marshals, you know, it has people that walk around with guns. You know, is it going to arrest Phil Berger and Tamara Berenger for trespassing if they try to come into the court? I mean, and what you get out of the order, besides that this is real and very serious, is that there is no procedure for this. There's not any precedent, there's no procedure, there's no rules. They are making it up as they go along. They are absolutely making it up as they go along.
It's nothing short of an exercise in creative writing. Typically, a lot of people who aren't lawyers may not realize this. Typically, when an attorney files a motion, there's something along the lines of pursuant to rule XYZ, pursuant to such and such statute. And then they ask for whatever it is they're asking for. When you go back and read the motion to disqualify in this case, they don't really pinpoint a rule of appellate procedure or a statute just to base their motion on. And I submit to you that's because it's not done. You know, this is a first of its kind motion.
And I'm not an attorney either, but I can tell you, as I've read through the 8 questions in the briefing order, by the way, I'm hoping that one of my colleagues here will be able to post this for folks to read this briefing order for themselves, of course, along with the stories that that Dallas Woodhouse has reported on this for Carolina Journal. But the last one to me, Jeanette, is the most interesting one of what I would just classify as they're kind of asking people, okay, how do you think we would go about this? If you want us to do this or don't want us to do this, how and why? Here's question 8. Should any such rules incorporate a process for the making of findings of fact? If so, what person or entity should make those findings, and what procedure should be employed in order to facilitate the making of any such findings? What should be the standard of proof utilized in making those findings of fact? So, Jeanette, that brings up, I think, an amazing question. Like, what are the guardrails here for determining that these two deserve to be booted off this case? Is there any?
There aren't any. Not at this point. And I think that's the court trying to get some feedback about how would we even go about doing this in a way that's not going to absolutely destroy the Supreme Court going forward. How should they proceed? Because it's never been done before. And one of the questions earlier in the briefing order asked the parties specifically to address what, if any, impact two particular statutes have, 7A-10 and 7A-10.1. One of the things that stands out about those particular statutes are specifically General Statute 7A-10.1 is that specifies that the court may, and I'll read it for you. The Supreme Court is authorized by rule to prescribe standards of judicial conduct for the guidance of all justices and judges of the General Court of Justice. So that statute uses the word guidance. So we have a code of judicial conduct and it's guidance. This is all about guidance. So I can't wait to see how the parties brief on that. And I think that dovetails into the last series of questions about findings of fact and standards and who decides. We're in uncharted territory here. And this is going to have a lasting impact, not just on this case, but on cases for generations to come.
Now, I want to jump in here because I think Jeanette brings up a question that was presented in the order that I found among the most fascinating. And Donna, if you want to look at it, I'm going to paraphrase, but it brings up not only the code of conduct, just so you know, and Jeanette, please correct me if I say this wrong, that, you know, judges have a judicial code of conduct. It's their rule book. It's their ethics and instructions. And it is administered by what is known as judicial standards. And judicial standards deals with the discipline of judges. They also put out formal advisory opinions, which are public. There are no such opinions that are related to these two issues. But the question is posed in a way in the order that makes you wonder something. And I've written this, and it is somewhat speculative, and I own that it is speculative. But the judicial standards provides judges confidential advice about conflicts and other matters that may come for the court, you know, looking at precedent and giving them guidance, and judges are allowed to rely on that. Of course, this is not a disciplinary issue at the time, but we very well could be looking at a situation where the Democrats on the Supreme Court are removing judges when judicial standards and the code of conduct would have cleared them to participate, which is another huge problem for the judiciary.
I think what you're referring to in the briefing order here is question 2. But this sort of gets to this. And Jeanette, once again, I'm not an attorney, so I'll tell you the question it brings up to me. Here's what question 2 says in part. Does this court have the authority to require the involuntary recusal of a justice who does not believe that self-recusal is appropriate? So to me, that gets to the issue of require versus request. And what would happen if this moved forward and there was a vote from the Supreme Court that said, Phil Berger Jr., you're off this case. And then Justice Phil Berger Jr. says, well, I don't agree with you, so I'm staying.
we could be looking at that kind of showdown. But my professional opinion is that the court does not have the authority to force the recusal of either Justice Beringer or Justice Berger. I think that is essentially trying to nullify last fall's election of those justices. I don't think that there is authority either constitutionally or by statute or rule to force that recusal, to force that disqualification. And frankly, if the court as a majority were to vote to allow this motion and disqualify these two justices, I don't see that it has any way of enforcing that. I think the justices could very well say, no, I'm proceeding with my duties. I've been duly elected. I have taken the oath. I am serving as I have been hired by the people to do, and I'm going to sit and hear this case.
There's also another question in the order that talks about the individual, as in the individual judge, do they have a constitutional right, having been elected, to hear the case? And I will note that that refers to constitutional rights, but doesn't specify. I think that leads you to believe that there could be a federal claim if these judges are removed, that at least in theory, under equal protection. I mean, Jeanette would be much better equipped to talk about that, but there at least could be an argument made in federal court that you have violated these individual justices' federal constitutional rights.
You know, Mitch, this whole thing, just thinking about it and hearing you all discuss what really stood out to you from the challenge and from the order, it strikes me as that it's not too out there to say that this really is a threat to democracy if this goes forward.
Certainly, and in some respects, it's trying to nullify major pieces of the last two election cycles in North Carolina, because the last election cycle was the one in which voters decided to put Tamara Beringer and Phil Berger Jr. on the state Supreme Court. They were the only new justices added. Chief Justice Paul Newby had been an associate justice before winning that race. So that was a major element of the last election cycle. And the previous election cycle was the one in which voters decided to approve an amendment for voter ID and to lower the tax cap. And remember, voters had the ultimate say there. There were six amendments on that ballot. They endorsed 4 of them and rejected 2 of them. So people weren't just rubber stamping something they didn't understand. They looked at what was on the ballot. They liked 4 of the amendments. They didn't like 2 others, and they had the ultimate say. But this case at its root is about trying to undo that election. And I think we've already made this point, but it's worth repeating. And that is, once you deal with this unprecedented idea of forcibly removing 2 justices from hearing the case, whichever justices are left hearing the case will deal with what seems to be an unprecedented attempt to try to rule that a General Assembly, because of concerns about unconstitutional districts, could then be declared usurpers who can't do anything like putting amendments on the ballot. That could open up all kinds of doors, because an amendment is something that the people ultimately get to decide on. But what about something like the state budget or some new criminal law that was passed by this General Assembly? Can't someone then go back, if this precedent is made, and say, well, I don't like that law you passed, and I was convicted under that law. And so since you were a gerrymandered legislature that put that law into place, I should have been convicted and I should be free from any penalties.
And now you're really getting into territory about separation of powers. I mean, that should be sacrosanct. But
I mean, if you are a lawyer representing a criminal defendant and they throw these amendments out, and you're a lawyer for a criminal defendant, convicted under any statute that's been altered in the last 8 or 9 years, it would be legal malpractice for you not to file something to try to overturn that person's conviction. And think about what that in itself would do to the courts. One other thing that I believe, is that yet we passed 4 amendments, the voter ID, the lowering of the tax cap, but then the other two that are regarded now as fairly uncontroversial, the right to hunting and fishing, and what was known as Marsy's Law about crime victims. At some point, those things are going to be implemented into various procedures, and somebody's not going to like something. Somebody's not going to like that somebody is fishing near them, or somebody's not going to like that they had to comply with some part of Marsy's Law. And it seems like to me that those amendments, under the same thought process, are equally invalid, and it could be years from now when somebody challenges them, but they would still equally be invalid. And so how the court going to keep those amendments? There's just no, so you're really nullifying 4 amendments if you do this, in my opinion.
Dallas, the other.
I'm sorry, Matt.
I was just going to go. Okay, I'll just make a real quick point, and then we could get to the better legal point from Jeanette. But the other political piece of this is the fact that the 4 amendments were passed, but the NAACP challenged only 2 of them, which shows you that basically they were picking the 2 that they don't like politically. They could have challenged all 4 amendments. And in fact, if their argument was what they say it is, that this was a usurper legislature and shouldn't have been able to put amendments on the ballot, they should have challenged all 4, saying that the voters should never have had a chance to see all 4, but they only picked 2, the 2 that they don't like politically. And they're trying to get the courts to do what they couldn't do at the ballot box, which was to get people to vote against this amendment. Remember, for those who remember back to 2018 and the political campaign surrounding the amendments, there was an active campaign tied to the Democratic Party, vote against all 6. They basically didn't choose particular amendments. They just told everyone, vote against all 6. The voters, to their credit, looked at the individual amendments, chose the ones that they liked, passed those, rejected 2 others, and now this lawsuit is basically designed to fight politically through the courts 2 amendments that they didn't like. Sorry, Jeanette.
Yeah, excellent point. It seems to me that if the plaintiffs in this case were intellectually honest, they wouldn't have challenged 2 of the amendments. They'd have challenged all 4. The fact is, whatever theory they're arguing, their theory that these amendments were unconstitutionally put to voters, they were all, if that's the idea, is that these 2 amendments were unconstitutionally put to voters because the legislature was gerrymandered, then all 4 of them are. You can't have it both ways. You can't be a little bit pregnant, which is what they're trying to maintain. And the fact is, as Dallas pointed out, if these 2 amendments fail on review at the Supreme Court, then so do the other 2. Just they'll fail in another lawsuit. They'll fail when somebody, ends up not complying with Marsy's Law and decides to take it to court and uses this case as precedent that there was a, quote, usurper General Assembly. And so the amendment was invalid. This is going to have repercussions far beyond just these 2 amendments.
And
this makes the raw, naked politics of it. It lays it to bear, because the reason that they filed the lawsuit that way, the reason that Judge Collins ruled the way, is so that if you can get it to the Supreme Court, that you can convince the Democrats you can throw the amendments out without having complete and utter chaos. That it does. I mean, there's just no logic that you throw the amendments out and not other statutes. There's no legal logic to throw out 2 amendments and not 4. That is all the political design of a lawsuit to try to get the votes. But what Jeanette and Mitch have laid out clearly is that this will that the amendments case alone has the potential to inflict all kind of chaos on the judiciary for years to come, not to mention the egregious attempt to recuse 2 duly elected justices.
The potential ramifications for the North Carolina voter here, I just find really alarming, because let's just play this out. Let's say that this occurs, this is successful, those 2 justices are removed. So why would a voter ever think that her vote or his vote counted at all? And would that in itself disenfranchise voters and suppress the next vote?
Oh, without question. Absolutely. Absolutely. If these justices, and we have a problem with voters, sometimes there's a big fall off, and you get a lot of voters who vote for other races but don't feel.
They'll vote at the top of the ballot but not get down to the judicial races?
Yes. So if these justices are forcibly disqualified, the Supreme Court might as well send up signal flares and go door to door telling voters don't bother to vote on judicial races. I mean, they voted, they knew Beringer had been in the legislature, they knew Berger's father is the pro tem. Those were not secrets. These are not justices who were elected before this case started, quite to the contrary. So voters were aware of all of those things and elected these people. If the Supreme Court does not allow these justices to participate and to fulfill their duty to the voters who elected them, it is tantamount to the Supreme Court telling voters, don't bother voting because we don't care.
And it is sabotaging your own body. It is sabotaging the judiciary. I mean, think about the effects that people now think the judiciary is so political. I mean, I'll give you an example. Something else I wrote for the Locke Foundation over the last few days, there was a great symposium on redistricting and reform over at Duke University. There were some really good ideas, some ideas the Locke Foundation supports, some ideas I think, may not go anywhere. But if you just believe that if the Democrats get in charge and they have the legislature and they have the courts and they're just going to make it up politically, why would you go through the trouble of passing the reform? I mean, you are, if you are elected to the judiciary, you have a responsibility to raise the stature of the judiciary. As Jeanette knows, the enforcement mechanism of the judiciary is basically its stature and its word. And if you voluntarily sabotage that by doing this, you cannot care about the judiciary. You cannot care about the courts. You can only care about the politics.
That's such an important point. I mean, the North Carolina Supreme Court, it's the last stop in our state. And if the credibility of the last stop falls to pieces, I mean, where are we as a civil society that is based in the rule of law?
And another thing I want to throw out there, Donna, you're absolutely right to ask that question. All of this, what the potential for constitutional chaos is coming about basically to kill off two ideas that are probably going to become law at some point in the future anyway. The vast majority of states have voter ID. Democrats and their interest groups who've been fighting voter ID have been fighting it now for almost a decade and continue to fight it. They will continue to fight it. But you have to think at some point we're going to have a voter ID. On the other hand, the state constitution already has a cap on income taxes. The amendment was just going to lower it from 10% to 7%.
And our tax rate is already below 7% anyway, so it doesn't affect anybody's taxes. I mean, Republicans have done a good job of lowering the state income tax, so we're well below 7%. And I mean, if the Democrats got in charge and tried to raise taxes above 7%, I mean, it would take a Herculean effort. You normally just can't implement a tax increase that large. I mean, it would take a number of years. I mean, so Mitch is exactly right that, I mean, how can they believe that the juice is worth the squeeze here when the net result might be not very much anyway, except destruction to the court, destruction to our process, lack of faith in institutions. I mean, we already have a real lack of faith in institutions, and the courts have been among the highest of respect, and this will destroy that for generations in North Carolina.
One other point we haven't made yet that is worth pointing out, and that is there are two separate issues. We've talked about both of them. One is the potential forced removal of the two justices, not only for this case, but as Dallas alluded to earlier, there's another case that would forcibly remove Phil Berger Jr. because of his father being the leader of the state Senate. So there's that issue. But then there's also the underlying issue in the case itself, and that is, can you throw out the duly passed actions of a General Assembly because of gerrymandering? And one thing we haven't noted yet is that the US Supreme Court has already said no to that particular action in the past, because every time it has thrown out a North Carolina election map, and it's done it many, many times, what the US Supreme Court has gone back and said is, okay, General Assembly, do it again. They didn't say, oh, because there was a gerrymandered legislature, we're not going to allow the legislature that was gerrymandered to rewrite the map. Now,
So in essence, you're saying the U.S. Supreme Court has already thrown out the idea of this so-called usurper General Assembly that hasn't done anything valid because it in and of itself is not valid. U.S. Supreme Court said that's not right.
They have, as far as I know, they have not come out with a ruling that said that this is a bogus argument that you can never use, but by their very actions, allowing the General Assembly that was determined to be gerrymandered to go back and then get another crack at drawing new election maps, that is a signal that they don't consider that General Assembly to be a usurper General Assembly. Now, in some cases, there has been a special master that's been brought in to deal with maps. But the General Assembly, even one that has just been determined to be gerrymandered, always gets a shot at redrawing election maps. And that is the US Supreme Court signal that even though we don't like these maps, we're not going to determine that you're some rogue group that doesn't have any legislative power within your state.
It's also an acknowledgement, and the Supreme Court has said this, that they've made a mess of redistricting law. And it's not like the Republicans in the legislature drew districts that they believed were gerrymandered and thumbed their nose at the court. They believed that they were drawing districts that the US Supreme Court was requiring them to draw. They believed, and it's so important that we have had all these redistricting lawsuits, but in almost every case, the rules have changed on the legislatures that have drawn the districts. So no Supreme Court would say that, because they would know you would have invalidated legislatures all across the country. The entire system would collapse.
It's simply impractical to have a court decide that a legislature with unlawful or invalid districts ceases to have constitutional authority to legislate. And the practical consequences of that are simply unworkable, absolutely chaotic.
As we
Donna,
round out our
before we
conversation
wrap
here
up,
this afternoon, here's what I'd like to hear from each of you. What are you going to be watching for the next development, so to speak? You know, what is there a particular question in the briefing order that you're going to be watching for the answer to, or is it a timing issue, or is it national attention? What should the people who are watching us now be watching for in this case? Because folks, this is the first of many conversations we're going to have about this. This is a huge deal, not only as evidenced by Dallas's reporting and analysis for Carolina Journal, first on the story, but now on Sunday, we have an editorial from the Wall Street Journal about what is happening here. The headline of their editorial, Scorched Earth Judging in North Carolina. This is national news. It's not just a North Carolina issue at all. Mitch, I'd like to go to you first. What are you going to be watching for as this develops?
Well, my simple answer is watch for the bylines from Dallas Woodhouse at CarolinaJournal.com, because he's going to be following it very closely. But I think the next big thing to watch for, really, unless there's some unexpected development, is what comes out in the briefings that the Supreme Court required. Because basically they asked, if we're going to do this, how would we do it? And you're going to see the lawyers for the NAACP and the lawyers for the legislative defendants give contrasting arguments about what can be done and what should be done. That'll be very interesting to see. Dallas is going to write about that along with any other developments as well.
Jeanette, what will you be watching for?
Well, I think one of the most important things will be the amount and intensity of national attention. I wouldn't be surprised, for example, if we see some friend of the court briefs specific to this briefing order. Even from groups that maybe didn't have an interest in doing a amicus brief on the merits, we may see people trying to come in and do a friend of the court brief on the recusal question, disqualification question. So as a lawyer, I'm going to be looking for those things, and also sort of fleshing out, seeing how the parties flesh out their recommendations to the court on how to handle this motion.
And Dallas, how about you?
So, yeah, we'll have the briefs come up in 30 days, and they have about another couple of weeks to get responses. You know, this is going to be an issue that is with us for at least the next 18 months. Through next year's election, it'll come up in the election. Depending on how the election comes out and depending on the action of the justices, there's going to be, some interest in the legislature to respond in all this. I think here's the most important thing that can happen right now. And that is for people to share the Wall Street Journal editorial today, to go on to Carolina Journal, put in the search, the one Supreme Court case that could destroy the judiciary. That's my original article. Spread this around, put it on Facebook, talk about it with other people. I am not unconvinced that we can't shame the court into not doing this. But we can only do it by that national attention that Jeanette referred to, by bringing it up locally. The Locke Foundation is going to continue staying on this like white on rice to bring it. But we need our viewers and our supporters and our detractors. I mean, this ought to be a bipartisan condemnation of this kind of behavior. And we need people to get it out, tell people it's real, it's important, and stay tuned.
All right, Dallas Woodhouse with Carolina Journal, and Jeanette Doran with the North Carolina Institute for Constitutional Law, and Mitch Kokai with the Locke Foundation. Thank you, folks. Appreciate your perspective on this. I know we're going to have you back. This is the first of many conversations, so thanks very much, and good work, all of you. And folks,
thank you, Donna.
We want to say thank you to you as well for joining us today. As you can tell, this is a huge story, not only for North Carolina and what it means for our future, about the will of the voters. Will we count as voters and taxpayers? What about the long-term credibility of the North Carolina Supreme Court? There are big, big issues at play here. Again, now a national story via this editorial from the Wall Street Journal on Sunday. So we would ask you to, as Dallas requested, be sure to check out carolinajournal.com several times a day. Follow us on Twitter, Facebook, and the team, also the legal team at the Locke Foundation, will be writing about this as well, johnlocke.org, and Jeanette's work. And Jeanette, what's your website before we say goodbye today?
ncicl.org.
That's going to be that'll be a great resource as well for all of the legal nitty-gritty on this, and Jeanette is excellent at that. She's also excellent in translating those legal things into language that those of us who aren't attorneys can understand. So you have a coalition of experts here who are working on this issue to make sure that you stay informed. I would ask you this: if you believe, like we do, that this is so important to North Carolina, we would ask you to help fuel the work that we're doing on this, to make sure you are up to speed on this threat to our democracy through this potential booting of these two Republican justices off of this case on the North Carolina Supreme Court. We would greatly appreciate your tax-deductible donation to help fuel the work. Just go to johnlocke.org. In the upper right-hand corner is the Donate tab. Just click on it there. It's safe, it's fast, it's secure. You can make your tax-deductible donation right there. We would be most appreciative of that. Hope you'll join us again next Monday for another edition of Shaftesbury Society. We've got another great topic planned for you. In the meantime, on behalf of the entire team, thank you for watching and have a great week, everybody.